line on Equa TV Africa, a program that discusses legal issues and current issues, especially as it relates to legal matters. This evening, we will be discussing the topic, the Electoral Act 2022, Salient Innovations. And with me in the studio is a legal practitioner and social commentator. Yes, it is no longer news that on the 25th of February 2022, the President of the Federal Republic of Nigeria, General Muhammadu Buhari, retired, signed into law the long-awaited electoral bill. It will be recalled that sometime last year, the electoral bill was sent to the President for his assent. He declined assent and gave reasons, which Nigerians were not agreed on whether those reasons were tenable or not. However, the National Assembly went back and made amendments to the electoral bill and retransmitted them to the President. And it was going as if the President wasn't going to sign the electoral bill into law. And Nigerians were wondering what was going to be of the election that is to come up next year. But fortunately, on the 25th of February 2022, the President eventually, finally, signed into law the Electoral Act, giving legal backing and guidance to the 2023 election that is just around the corner. Already, by the signing date of the election, it was clearly shown that some of the innovations in the Electoral Act were caught up with time. Well, I will not preempt. That is what we'll be discussing this evening. And Barrister Matthew will be doing justice to that. In the second segment, we'll also look at the by-election that was conducted last Saturday, particularly the one in Plateau State for just North Bassa Federal Constituency and the Panshin South State Constituency of the Plateau State House of Assembly. So, Barrister Matthew will start right away. The Electoral Bill was signed into law, thus becoming an act of the National Assembly on the 25th of February 2022 by the President. At one of the programs, we were asked whether the President was right or wrong, and we declined comments that he was still within time, so we cannot preempt what he was going to do. Yes. And it was good for any one of us not to preempt the President because we were not sure what he was going to do. And finally, he has signed. What do you have to say in relation to the signing of this Electoral Act?
In fact, the signing of this Electoral Act by the President, personally, I'm surprised. I never expected that such gesture will come from the President. Now, many people have different perceptions as to why he signed. There are others that say that it's as a result of pressure from international communities and even certain democratic forces within the state. And there are others that are saying that he has no any other option than to do that. Other school of thought believe that he's rounding off his tenure, so he wants to leave a legacy to the country. But whatever it is to me, the signing of this bill, now an act by the President, is like a Christmas gift in June in anticipation of what will happen in December. I never expected that. It was a surprise for me. So it's a hope that if you start accepting gift and start acknowledging gift from June, it means that the December is going to be green. So I think it's a good omen for the 2023 election, especially with respect to the electronic transmission of results.
Yes. Now, you have already mentioned the electronic transmission of the results. What other innovations are there in the Electoral Act 2022?
There are many innovations, and I think one of the innovations that I'm mostly interested as a practitioner is the power of INEC, okay, to use the total vote cast, okay, the number of the accredited vote in determining whether there's a whether there's overvoting.
Yes.
You rely on the number of the accreditation,
Yes.
you rely on the number of the total vote cast, and then you can be able to find out whether there's overvoting or not. So you now find out that relying on overvoting is not only restricted to the situation based on the valid vote cast, but also on the number of the accredited votes. And mostly in practice, sometimes the challenge you have is that the opponent or INEC now will say that, okay, some people may have been accredited, but in the course of the what conducting the election, they are not there. So they normally rely on the number of the vote cast to determine overvoting. Now the court said that by the rules, you can equally use that. Then another thing is the INEC is empowered by this law to now exercise discretion and jurisdiction where an election result was signed via duress, and say that he signed this as a result of threat to his life. For example, what is this innovation seeks to cure? You remember the case of Rochas. The electoral officer come and said that he signed it under what? Duress. But court still went and said there's nothing they can do. So now the act is now saying that where there's issue that has to do with duress, the INEC now has power to what? To review the result there. Look at also the case of it is now include in encouraging violence in determining who should determine the real results that is there. So all I need to do is to allow the electoral officer to go on with the election. I will hijack him, put him in one hotel with threat to his life and say, okay, declare this result. So they are saying that no, where there's duress, INEC has a power to review it. So these are some of the innovations that are statutorily. Remember, most of the judgments of the Supreme Court, when cases come to like that is not statutorily addressed, they have to make a notable pronouncement, which is another way that the Supreme Court or Court of Appeal is crying that this is how the law should look. And so they say now, give it this semblance. And I believe that the lawmakers are able to listen to them and give a hint to that. So these are some of the few that we can talk about. There are many others that maybe in the course of the program we'll talk about.
Yes, there is one issue that was a contending issue in the electoral bill that was not signed by the president, and that was the issue of direct, indirect primaries. Where do we stand in the new law?
Yes, the issue of the direct and indirect primaries that was not signed, I personally, like I said in the previous program, I respect the wish of the right of the president. I also thank God that he signed the will. Now, by signing this now, parties still have the right to exercise it. You can't restrict them to only a particular means. You give direct or indirect as an option. So these are some of the things that you would give it open to them. Now, apart from that also, you can also look at other aspects of the election that I will talk about. There is a provision there under section 84 sub 12 that the president is not contended with. The one that is saying that anybody aspiring for political office must put up his resignation. If it's in the executive arm of the government, he must put up his resignation before contesting. So you find out that this amendment now also are some of the facts that emanates from the duel between the executive and the legislature. So the legislature are saying that some of these guys in the executive, they normally have monies that before his hiring and coming into politics, the guy does money and then to come and intimidate us. And now they are saying that no, let's have a separate class if you want to put up your resignation. And I'm happy somebody in Akwa Ibom did that recently. I saw it online. Secretary or Chief of Staff, I think something along that administrative.
Well, but even before now, those in the executive arm, especially those that were political appointees,
yes,
well, even though there was a court pronouncement that they are not public servants,
yes,
in the category of requiring them
yes,
to resign before contesting election. However, most of the governors will tell their commissioners that if you want to contest the election, you first resign. In fact, some resigned last year by 1st October 2022. Some people who were holding public offices resigned so as to contest for election by the directive of the chief executive of their various states.
Yes.
So, to my mind, that is not so much of a new innovation. For those that were in the civil service or in the public service, it was incumbent. The principle had been there. In fact, it's contained in the Constitution. It's constitutional that they have to resign. So, is there any innovation different from what was there?
In fact, the innovation is this. From the decision in Ahmed, I think versus CBN, that talks about Yaradua, this civil servant, court held that neutrality is one of the virtue features of civil service. The court held that no, doing so is discriminatory against them. That pronouncement is a common law pronouncement. The issue of the Constitution that saying that it should stand and the administrative directive is a direction. But the coming of the law now, it is specifically stated that this is what is there. So that is the innovation. There are certain laws that operate based on judicial precedent. And one thing with Electoral Act is that in its evolution, it seeks to cure some of the defects that emanated from judicial precedent. A typical example is that what is the import of electronic transmission of result from this Electoral Act that we are looking at? The import of electronic transmission of result is that it clearly shows that transmission of result can be done electronically, okay? Yeah. And that should be used. Server should be relied upon as a what? One of the bases of determining the validity of election and determining the counting as reflected in the server. Then also, you look at what is the import of our jurisprudence. That overturns the decision of anything like server, and they say they don't have anything like server. But with this judicial precedent, with this legislative amendment now, it clearly put them on the road that yes, you have a duty to show that that server exists and it can be reckoned with. The challenge for us lawyers here is for us to now bolster our knowledge and understanding of the ICT law. Knowledge of IT are some of the issues that we should look upon. We should not now look about only the issue of books alone. It has to be with experts. Remember in the Abubakar versus INEC, an expert was brought from Kenya. And one of the issues is that if you are bringing him from Kenya, a lot of things relying on electronic evidence, we are going to have some elements of foreign influence in our election. Because cyberspace, whatever server you will use, is not only restricted by Nigeria alone. You will find out that yes, one person or the other will have influence. So these are some of the issues that I think are mostly applicable. Vision of 180 days. 180 days, I think it's equally a good development too. Yes. That people are looking. It's a good development so that people should look. But I think in my little experience in election petition, what I was expecting for that is to see how they can extend the scope, the period for conducting election. It's not easy. Yes.
Yes. Let's go back to this issue of resignation from public office. As I said earlier, the Constitution made the provision that for civil servants or public servants who wish to contest election, they have to first resign their offices.
Yes.
Now, what is the difference between that constitutional provision and the present provision in the Electoral Act?
Okay, the difference now, with respect to the supremacy of the Constitution, specific legislation exists over a general legislation. There is mostly inclination by the court to give preference to specific legislation. So now, if the Act clearly provides in this case now, the Constitution is only what? It's only adding strength to what the Constitution says. Because, for example, now, a typical example, you say that National Assembly has power, isn't it, of oversight function, challenging corruption, checking corruption cases, and other, even scrutining people. But if the National Assembly acts and privileges as clearly specified that it is now its power is now driving from the Constitution, so it is given a specific power, are not explicit. So you find out that they found themselves mingling within the rules of interpretation. Can we apply mischief? Can we apply golden or literal rule? But where a legislation further specify, okay, from the power that is in the Constitution, a particular legislation, court is now inclined to give it a specific interpretation. And that's why, like in order, let me just put it in this way. If, for example, now we're talking of appointment of ministers, isn't it? Resignation, let's say we have a law, ministers contesting in ministers contesting election, in bracket, Resignation Act, and then you have the Electoral Act. So where there's a conflict between the Electoral and Ministers Designation and Resignation Act, the Ministers Designation and Resignation Act will apply because if it deals with a particular minister or a commissioner, because a specific legislation. So that's what that law seeks to achieve in that regard.
Yes. Let me ask more. Does this include governors, the president and governors, or only other people in the executive?
By the rendition of that law, it equally...
I mean, the Electoral Act.
By the rendition of that law, it equally includes them. It includes them, not only the committee. That's why you see some people are now talking about setting... the president himself is not happy with that law. If you look at it, he wrote a letter, I think, asking them for the expungement of that section or to consider that section, to reconsider that section. Now, his argument is pulled from what you earlier said, the school of thought based on the decision of Yar'Adua was showed that civil servants can participate in election, abiding by the doctrine that they are politically neutral, deprive them of their right to exercise their franchise. So now Buhari is relying on that and saying that it is depriving them of their liberty. The issue now is that this law is not saying that, no, we want to check a situation whereby some people will still hold onto the executive, manipulate the election into the legislature, and then see how they can manipulate things. So these are some of the issues. It's a fight back between the legislature and the judiciary, and they were able to get it this time around to their favor.
Anyway, let me ask further. If you look at it, Muhammadu Buhari, the president of Nigeria in 2019, was contesting for presidency.
Yes.
Atiku Abubakar was also contesting for the same seat.
Yes.
President Buhari was flying the presidential jet through Nigeria campaigning. The jet bought with Nigerian money and fueled by Nigerian money, and the pilot paid by Nigerian money, paid with Nigerian money.
Taxpayers' money.
With taxpayers' money.
Yes.
Then he was, anywhere he went there as a president. He was received as a president. He lodged in the presidential lodge of that state. Then Atiku is contesting with him and not having those benefits, not having those privileges. He's going about with his private resources. Don't you think that is unfair?
In fact,
don't you think the president, and that is just a minute part of it, there are several other ways that the president could use his influence to influence his election. So don't you think this is justice? This law is justice to that extent? In
fact, you are talking as if from the informed position upon which that electoral act was passed. I was able to discuss with a notable member of House of Representatives, I think some whiles ago, we were discussing this. And he said that these are partly some of the reasons, because they control the machinery of the state apparatus. Remember the cases that happen. They want to intimidate the party chairman. They want to influence while they are still in power. But my problem with that provision of the Constitution of the Electoral Act, is that with respect to governors, with respect to the president, it does not explicitly state, the Constitution does not explicitly state that he must resign. If you look at the provision of the Constitution on the governor, election of governor and the president, you say they can go forward, say continue, but it does not provide for whether they can. So these are the issues now that we can subject it to judicial interpretation and interrogation. Does that equally extend to the governors or to the president? Must he also resign from presidency? And if he resigns, who becomes the president? Is he the vice president? Remember, the mandate of the president and vice president is what? is the same. So these are some of the issues. And I think by thorough rendition, the court may likely say that it does not include the president, because doing so will make the office of the president and the vice president vacant. And so you find out that the next person that will be in the order of precedence may be the state speaker, House of Assembly, or the Senate president. So what about them? Are they also not contesting election? So when an interpretation is given to that effect, it will lead to absurdity. So the court may say, no, that does not include the president, but it may include other executives, like maybe the commissioner, the ministers, the chairman, the permanent secretaries, amidst others. These are some of the people that may likely be the subject matter of the interpretation and application of that section.
Yes. Another issue, this issue of a candidate dying during the conduct of the election, it happened in Kogi State in the 2015 general election, and it was, Nigerians were divided, and the Supreme Court gave its own judgment, even though it was heavily criticized that by reason of a candidate, you mentioned earlier that the mandate of the president and vice, or the governor and deputy, is one. So if the governor is there, it is also within the contemplation of the people that deputy governor could one day become the governor. Because should the governor die in office, he becomes governor. Should the governor become incapable of functioning in that office, he becomes the governor. Should the governor be sick, he becomes the acting governor. So he was within the contemplation of the people that he could become governor. So he can act as a next of kin. He can inherit that mandate. But to bring someone from the blues who was not part of it, who was put with the place side by side with the governor, and he was rejected, to bring him to come and inherit that mandate is wrong. But well, the Supreme Court made a pronouncement and it became law. Now, what does the present act provide in that respect?
In the present act clearly addressed that lacuna, because I remember that time it was Prince Audu Kogi, I believe,
yes,
of the counting. Remember, he was not even sworn in when he died.
Yes.
So the main issue now is the issue of swearing in when he died. That's the constitutional. If he has sworn in when he died now, that is when he took the oath. The deputy governor will have been a beneficiary of that constitutional provision. But where now it is stated that there have been there's an election that's going on and was declared a winner. Now with these provisions, where it is declared like this, the person that died, case of good luck, there was a petition that good luck was should not contest, and first argument was that no, good luck at that first time with Yaradua was a deep so and or second time, then they are saying that he ought not to be the president. So these are some of the issues. Now with respect to this Electoral Act, his vice president elects, may if the president dies, God forbid, or if the governor dies, the vice president cannot automatically
of a candidate while the election is ongoing when we come back from the break. So we'll be going on a break. When we resume, we'll continue with the discussion on the Electoral Act and then proceed from there to the Thank you for staying tuned. We were looking at a situation where a candidate dies in the course of the election, while the election is still ongoing. And I was asking, what does the Electoral Act provide? Does it make any provision on this issue?
Yes. In fact, from the angle of political parties' conduct of election, the various parties affected by such incidents can decide to replace a candidate. But not the fact that even if they are declared winner, it's not a license for them to assume office. That's the difference now between the administrative tax and then the political tax. For example, like I said earlier on, if the incident repeats itself, a candidate will emerge as a winner before the declaration of the election or after the declaration of the election, he dies. The party may decide to say, okay, we have somebody to substitute him. But it's not a guarantee to say that since he has died after the election, then the governor, the deputy governor should become. There are two distinct things. This first one, this 34, gives the party the second opportunity to reproduce a candidate so that it can rejoice and enjoy the fruits of its victory, but not necessarily giving them direct access. For a person to enjoy the office and to benefit from the succession of the president to vice president, deputy governor, there must be an oath of office.
All right. Yes. So, yes, the phone lines have opened. The phone lines are on the screen. You can call to make your contributions or ask questions, as the case may be. Professor Matthew, we will go on to look at the election that was held last Saturday. But before then, let's look at this issue of accreditation. You remember you mentioned the case of Wike versus Peterside, where the court refused to recognize the use of smart card reader.
Yes.
What specific provision did the Act make on the issue of smart card reader and other technology devices?
Yes, it's make a provision for electronic devices to be recognized, the new Electoral Act. And like I said earlier on, transmission of the result. And from the issue of transmission of the result now, give the use of server a judicial recognition in our electoral law. It gives accreditation a judicial recognition and card reader a judicial recognition. If you look at our laws prior to that, issue of card readers are mostly mentioned in the manual and electoral guideline. Only you don't find them in the statutes. Now, with the coming of this Electoral Act now, it is clearly giving us a hint that there is recognition of server. That was why I said earlier on that it helps in bolstering the texture of our jurisprudence now, electoral jurisprudence. That is our electoral law. It now does with substitute and suspends the judicial precedent and Abubakar versus INEC 2020 that say server is not recognized. The other precedents in Peterside versus Wike and other electoral jurisprudence that disregard accreditation, these laws now appear to cure it. Just like the decision that the Electoral Act 2010 also cured the defect in Amechi versus Celestine Umahia, or Umahia, I think the name. Umahia. So these are some of the issues that this law seeks to achieve. So it has cured a lot of things. So by this now, like I said earlier on, and I will repeat, is a challenge for lawyers now to embrace ICT law. We must know the position of law. We must know how ICT operates. We must know how electronic evidence operates, the admissibility. Thank God the 2011 Electronic Evidence Act recognized electronic document and recognized some of the ICT and IT and even visual social media as some of the documents that you can. So we must also improve our practice to look towards those areas because we are now going to digital era of practice.
Thank you. We will now move on to the by-election that was held across the country last Saturday to fill mostly National Assembly and State Assembly elections in constituencies where either people lost their elections, lost their petitions at the Election Petition Tribunal, or where candidates were dead and they needed to be replaced. In Plateau State, there was the House of Reps member representing just North Basa Federal Constituency,
Yes.
and who died, and also the Panshin South member representing Panshin South in the State Assembly, who was our colleague that also passed on. Now, what do you have to say about the election, its conduct, its participation, and all? And how do you rate INEC in the conduct of this election?
I would like, before commenting on that, I would like to appreciate God for the life of the members that serve and they are no more, that gave birth to this election. Honorable Maitala, who is deceased, and Henry Longs, who is also deceased from Panshin. I think I would like to speak, as an observer. I noticed this thing with the election from where I observe.
Okay, here we have a caller calling
Hello.
from Benue State. You are on there, you can go on. Yes, you are on. Go on.
Okay. I want to thank you for your. I want to thank you for the special exposition on the television. I'm calling from a different in the state. I'm the lawyer. Illustration that what happened in Kogi sometime 2015 happened. What is the strategy? If in the course of, if they have declared the results, but the man has got his warning, so what is the position of the opposition party? If they now, will they now conduct a first election? To replace, because the other man, the deputy governor elect will not take the governorship position immediately. So what happens to the position? Is there given a position to involve in the election?
Yes, that was the kind of situation that happened in Kogi State. The provision, like Barrister Matthew mentioned, Section 34 of the Act makes provision that in such a situation, the party will be given the privilege of conducting primaries to replace that candidate. In Kogi State, someone was brought from outside who replaced by resolution of the party. So now the law has provided that a by-election will be conducted to fill that vacancy.
I think also when a candidate dies before the result is declared or before he's sworn in, it's not going to be a general election that INEC will conduct. No, it is the primary election that parties will conduct. They are not going to do that by a resolution. They are going to hold it via primary, that this is the person we have. That's what the law says. It specifically provides for primary conduct of election. So these are some of the things that should be done in such situation.
Yes, back to the point we were making about the election.
Yes, the election in Jos South has a lot of intricacies, because one, from the angle of the preparation of INEC, I noticed that there was no incident form as it's been done in the previous election. The essence of incident form is that where there is a failure for machine to capture you during accreditation, once you have your valid INEC voter card, then they look at your name from the registers of voters of that polling unit. They can now fill an incident form, but that did not happen this time around. Virtually most of the INEC staff were asked, they said they were not given that. Now, aside from that also, there was apathy. I cover a particular ward, and that is specifically Maza in Jos North. And during the course of the observation, we interacted with some people in that area. And some of their response is that they had a party of coming because the attitude of the government in the previous local government election that excluded them. So they felt there's no need for them going to vote. Now, another thing is that we find out there's a problem of voter enlightenment up to now. Because some people are even asking that for them to vote, I have to give them money. I say, no, I am not a political party. I am just here for. They said, no, that even as I'm doing these things, they are paying me. Then we also need to know the local party. Let me give you a very, very pathetic statistics. In a polling unit of about 721 people, you find out the number of people that come out to vote is 40. Another polling unit that has 504, you have the people that come out to vote is around 30. A polling unit that has about 507 people that came out around 28. Some is even 50. So you just find out that an aggregate of a polling unit that is supposed to bring about 5,200 something votes, the people that came out to participate in the election were not up to 700. So you can see the dismal performance in terms of turnout. And what is the issue? These are some of the things. Now, the intricacies between the party there is that some people equally say that people equally engage in protest vote. They say that the candidate they won in PDP is not the one they see, so they say they are going to vote towards that direction. Incidentally, some people say that since the candidate they won is not given in PDP, they are now relaxing from participating in the election. Others say we are going to vote for that party. Within the APC, the drama that ensued, a particular candidate came out and he was endorsed during primaries as the main candidate. Then certain people, specifically the comment of Sheikh Yahya Jingir, has altered the election on the plateau from religious coloration to a nationalist and patriotic perspective. Now, the video went viral whereby he's insinuating that they are voting PRP. And the candidate of PRP, based on that, is based on religious ground. So the vote of PDP is APC, is divided between loyalty to PRP and loyalty to APC. So few people within that area did not buy his idea, Ajingir's idea of voting based on religious ground. They were still loyal to the party. They voted for the party, not PRP. And then PRP, incidentally, came second, PDP first, then followed by APC. Now, the question now is that had it been APC in a solidifying state, it is clear that APC may have won that election because they appear to be apathy in most of the areas that are presumed to be PDP supported areas, nominated exported areas. So you find out these are some of the challenges. The other thing to look at in the election is that we notice certain intra-party feuds and some lack of transparency among the party members that reflected at the election poll. There was a polling unit in Jos. We learned that the agents of both PDP and APC are united in refusing to sign the election result because they say their party has not paid them their agency fee while watching that. So they went there. And at the collection center, we learned of the PDP, a PRP guy, that's the agent of PRP, refusing to sign the result on the ground that until he sees the main result as reflected on the server. So now some people are laughing and saying that, what does he need to do that? Ahile, let me tell you, we have to be careful. This election was conducted when? Saturday. 26th. When did the president sign the electoral bill? Friday. He signed it on Friday. And if you look at the particular session we are talking of, you can't take his story for granted. But the only thing that will help us is that if the server will be shown that this is what is planned, that will be there. But I don't totally subscribe to his argument because server, in the process of counting of result, from the sorting, counting, and even taking to collection center. The Electoral Act does not provide for seeing or citing of the result on server as a condition precedent before an agent can sign this result. But anything we shall be doing as lawyers, we should be very circumspect that this law just came a day after the Plateau State election. So the question is that, before the Plateau State election. So the Plateau State House by-election is just a day after the signing of that election. And you know how the law operates. So these are the challenges that we need to also ask God to help us with the grace to sharpen our acts, because there will be a lot of jurisprudential engagement when it comes to election petition after 2023.
Yeah. So, so what do you have to say to Nigerians in relation to the task ahead?
Yes, the task ahead.
In relation to the new electoral law and the conduct of elections next year.
We have a lot to do. One, voter sensitization, we are low. I can tell you categorically from the experience I had. And many are elitists. Now, some people say that what affects the polling units, some polling units in justice, because students are on strike, and then students, most of them registered there. That could be rationalized. But I think we need to do massive enlightenment. As people go out to preach to people, they say need to also go out in masks. Let's have NGOs that will be going to rural areas and sensitize people that you need to vote consciously and then strategically to reflect your interests and to protect your interests. As of the electoral laws, lawyers, like I said earlier on, should embrace ICT. Practice now is no more about the book alone. We should also learn about it. With the election transmission of results now, we should also learn how to move with the pace. Societies should equally embark, civil societies should equally embark on enlightenment politically. There should be statistic studies and surveys. Look at this polling unit now. You can go around before the election. You can go now, conduct how many people are in Ngorogo polling unit. You can take the picture. You can check how many people are in Likazore, how many people are Sheguna Abba, how many people are in Jenta Damu. You can do that so that I can have a statistics. As this result ends up in just now, setting angels should help us also to find out how many voters, invalid votes are there, how many invalid votes we have, how many invalid votes that are as a result of what? Lack of proper thumb printing. Some people will thumb print PDP and they say, oh, their intention is APC. They will come. Then some people will now talk about APC and PDP. They will sandwich it between, they will put it between APC and PRP. That's invaluable. So our people need education. And I will plead with the church in here to also help. And I will discourage raising religious sentiment in issues like this political nature. Don't ever politicize a particular religion with a political party. It is against the Constitution of Nigeria. That's why the INEC clears and the Constitution prohibits registering of political parties on ethnic and religious ground, because we want to cure the impression that we had in the First Republic, where we have NPC for the Hausas, AG for the Yoruba, and other
NCNC.
people. NCNC. You know, I remember the colonial, before the colonial one, there's Igala Union, Ibira Union, all these as political associations. So they call it no. So when an elder statesman comes out to promote that, he should be called to order. It's not decent for our democracy.
Thank you very much. This is where we draw the curtain for the program today. Thank you for coming, Pastor Matthew.
My pleasure.
And do make time with us next Wednesday by 6 p.m. and you will not regret it. Thank you for watching and God bless you.
Okay.